Hello, good evening guys. My name is Emily Davis and it's the 11th of April today, and this is part 2 of a video about council tax and how you're not in a contract to pay this unlawful tax. Moving on from part 1, which was just sharing with you some information, some details about contracts and about the letter that I wrote to my local council when they issued me with a council tax bill, which I sent back to them. They did reply to me. I sent my original correspondence on the 22nd of March and they replied to me on the 24th, saying, Dear Sir stroke Madam, thank you for your letter dated 22nd of March 2016 regarding your payment of council tax. I'm sorry that you have cause to write in about this matter. I forwarded your letter on to officers for further investigation and have asked them to look into the concerns you've raised and contact you directly. Thank you for bringing this to my attention. Yours sincerely, Doug Patterson, Chief Executive. And somebody has PP'd and signed that. I don't know who it is, can't make it out. Probably his secretary. It took a few days to reach us, and we sent another letter back to him. I'm going to read that out to you now, and I'll post what I've written in the notes under the video. Okay, so here we go. Dear Doug Patterson, thank you for your reply to my correspondence of the 22nd of March 2016, the contents of which are noted and will be kept on file. We note that you have addressed us as Sir stroke Madam. Does Doug Patterson, in the position of Chief Executive Officer of London Borough of Bromley Council, not know whether Baroness Emily of the House of Davies is a man or a woman, and how to address that man or woman as such? We firstly would like to make it known that we do not write to you with ill will or vexation, but instead with peace and the intentions to share truth and fact, to properly equip you in your position as Chief Executive Officer of London Borough of Bromley Council. 1. We note that you have claimed we have raised concerns. We must advise you, Doug Patterson, that we have not raised concerns. We have presented you with matters of fact and plainly given you our decision to decline your offer of contract. 2. We note that you have delegated our letter to unnamed officers of London Borough of Bromley to deal with it, who you claim will contact us directly. We advise you that the unnamed officers that you have delegated this matter to have returned the offer of contract. Sorry, just to backtrack there. Meanwhile, the day after I received their letter back, they simply sent the bill back to me. So that's what I'm referring to in that part of the letter, that they have returned the offer of contract to us. So I've obviously not been capable of understanding either the instructions we gave you in our correspondence on the 22nd of March 2016 or fulfilled the task to file the documents and close the matter. And we must also advise you that this is not a bat and ball game. We'd like to take this opportunity to be frank with you, Doug Patterson, and to give you full disclosure. Our only intentions are to make you aware of the facts so that in your position as Chief Executive Officer of London Borough of Bromley Council you may act accordingly, not only for the benefit of all the inhabitants who live in the borough but for yourself as well. We are aware that London Borough of Bromley Council claim the people's liability of council tax under the Local Government Finance Act 1992. We are also aware that this claim is in no way valid, and we must take this opportunity to advise you of this fact. The reason the claim is invalid is because a statute or Act of Parliament is not a law and cannot be referred to as a law. In fact, to refer to a statute or act as a law is fraud by misrepresentation and malfeasance in a public office. The actual definition of a statute is a legislative rule which is given the force of law by consent. This is agreed fact on and for the record, and we must advise you in no uncertain terms that we do not consent to be governed by HM Parliaments and Governments plc or any of its sub-offices. We now enclose the affidavit of truth and statement of fact by Baron David Wald, and highly recommend that you read it and then read it again. We recommend then that you read it again, and if need be, until you can fully understand and digest the content of the document, for within its pages lie the proof that first the consent of the governed must be acquired before an act or statute can be enforced lawfully. Please see Exhibit B, Case Authority, David Wald v Warrington Borough Council on the 30th day of May 2013, case number WI05257F, where following due process at HM Courts Tribunal, David Wald proved this and won the case. We must also advise you that the enclosed affidavit has been served on circa 657 MPs in office, the Secretary of State, the Secretary of the Crown and many others, and it's not been rebutted to this day. It therefore stands as agreed truth and fact on and for the record. If any individual group or company, or any individual group or company instructed by another individual group or company were to lawfully be able to enforce their will on another with no legal agreement or contract, this would amount to an act of terrorism, and we would be living in a state of tyranny where people would be carrying on like Dick Turpin at will whenever it's suited. This is common sense, and a man in the position of the Chief Executive Officer of a borough council should easily be able to comprehend this, and if he continued his actions to enforce his will or instruct others to enforce his will on any individual group or company without the legal agreement or contract, he would be guilty by his own actions of premeditated terrorism and could be incarcerated for an indefinite term. Now that you are aware of these facts, for you, Doug Paterson, in the position of Chief Executive Officer of London Borough of Bromley, to ignore the facts that statutes are not law and that our consent by way of a formal contract that is entered into by all parties wholeheartedly, willingly, showing clear offer and acceptance and giving full disclosure and is duly signed in wet ink by all parties, would be premeditated fraud and malfeasance in a public office, and you would be liable to answer to your actions for the crimes that they are, either by way of incarceration of 7 to 10 years for the fraud, the latter for multiple instances of, and 25 years for malfeasance in the office, to be served consecutively, or commercial charges to the same degree. These crimes are extremely serious, and you must take time for consideration before you act on this correspondence. In the previous year of 2015 to 2016, we were not fully aware of all these facts until the summer of 2015, and we actually paid the council tax in full with honour from a valid bank account with cleared funds available, of which your staff refused and made various claims which to date they've not provided any material evidence for. Your staff, namely John May, George Talaxi and Peter Turner of London Borough Bromley Council, whom you are ultimately responsible for, have been made fully aware of their obligations of service as officers of London Borough Bromley Council and will shortly be offered an opportunity to resolve the matter or take responsibility for their actions and answer to them. To date, by not providing any evidence to their claims, they have tacitly agreed to these claims being fraudulent in nature and fraud by misrepresentation and malfeasance in the office. And at this point, it is prudent for us to advise you not to delegate this matter and to deal with this yourself and resolve it. Because ultimately you are responsible for your staff's actions and you have to be accountable for them. And what is also important to note is that all officers of London Borough of Bromley Council are accountable for their actions personally. The actual London Borough of Bromley Council cannot be responsible as it's a company formed by an act of registration and it is of no material substance. It is the people and their actions that are accountable because they are of material substance and presentable as such. And this includes you, Doug Paterson, in the position of Chief Executive Officer of London Borough of Bromley Council. We would draw your attention to recent lien undertaken against an officer of the council who is also an officer of the court. We referred earlier to commercial charges, and these commercial charges are undertaken by issue of a security by way of a lien. And then I go on to, I won't read all these links out to you, but go on to list some links to published liens for people who have done similar things, making claims without providing any evidence whatsoever. And then, nearly finished, I go on to say, and this is very important, this part, I'll read you out the letter afterwards, which confirms all this, but we would, which was included under the same cover as this letter, we would like to draw your attention to the material evidence that there is no authority for debt collectors or bailiffs to act in any capacity, as confirmed by a man called Andrew Wilson, who is in the position of Deputy Under Sheriff of Greater Manchester, and he represents a company called Andrew Wilson and Co. High Court Enforcement. That the office of High Sheriff, who gives the bailiffs and the debt collectors their authorisation, so we're led to believe, became purely ceremonial after the introduction of the Courts Provisions Act 2003, and as of April 2004, High Sheriffs of counties no longer have a role in the enforcement of civil proceedings in England and Wales. Lastly, we would like to draw your attention to the fact that court orders are not valid, as judges do not sign orders in wet ink and seal them with official court seals, ever. This is fact. The liability orders are not even filed on them for the record, and this is because they don't exist. This is also fact. So any court official or public servant serving as an officer of HM Parliaments and Governments plc and any of its sub-offices, including London Borough of Bromley Council, are acting fraudulently if they act or instruct others to act upon unsigned and unsealed court orders, because they're not in fact orders, they're just pieces of paper with words or marks on it, and not actually an order. They're just a document that pretends to be an order. We enclose also the apostolic letter from Pope Francis himself, who confirms that all protections of the Vatican have now been taken away from court officials and that they are responsible for their own actions. We have laid out how anyone acting fraudulently will be dealt with commercial charges to the same degree as incarceration terms that would be given for these crimes of fraud and malfeasance in the office will be issued. The time has now come for you, Doug Patterson, in the position of Chief Executive Officer of London Borough of Bromley Council, to now consider the facts presented here and act accordingly with honour. We have literally spelt everything out for you in plain terms, so you are now aware of the consequences of each and every action that you take in your position as the Chief Executive Officer of London Borough of Bromley Council. We await your response. All correspondence will be kept on file without ill will or vexation. Yours sincerely, for and on behalf of the Principal Legal Embodiment by the title of Miss Emily Davies, for and on behalf of the Attorney General of the House of Davies, for and on behalf of Baroness Emily of the House of Davies. And we include with the letter Baron David Ward's affidavit of truth and statement of fact, the material evidence of the fact that the High Sheriffs don't have any role at all, and that goes like this. I won't, there's the, hold on, there's the letterhead there, Andrew Wilson and Co. It's not actually my address, so I don't want to put that on there whose address it is, because I haven't got permission. But in any case, the letter says, the High Sheriff of Greater Manchester thanks you for your formal notice dated 12th of October and has asked if I would respond on her behalf. I'm afraid that the office of the High Sheriff became purely ceremonial after the introduction of the provisions of the Courts Act 2003. In April 2004, the High Sheriffs of counties no longer have a role in the enforcement of civil proceedings in England and Wales. Accordingly, the High Sheriff is unable to help you with your action, but wishes you every success in pursuit of your claim. And so that was just somebody had filed a notice to the Sheriff. So I'm just going to show you that, because that is the letter. And you'll see Andrew Wilson, you can check this out for yourself if you like, Deputy Under Sheriff, and he signs that personally, and this is what he confirms. Okay, so so then we come to the Courts Provision Act. But the fact is, if the court or a judge or some officer of the courts is supposed to give these debt collectors, bailiffs that the council instruct, or anybody instructs, any company, the judge isn't going to sign it. It's not going to be signed or sealed. So therefore, is it valid? Do they have authority? I don't think so. And if they do, who gave it to them? And if a judge did sign it and did seal it, who gave that judge authority? Who gave somebody authority over you? So, also the letter from the Pope that I referred to, you can go on to the Vatican's website. If you just type in to Google apostolic letter from Pope Francis 2013, September 2013 I think, you'll find that letter where it says with criminal proceedings that basically if court officials, doesn't matter who it is, whether it's judges, clerks, whatever, if they act fraudulently, criminally in any way, they do not have the protection of the Vatican anymore. And they are responsible for their own actions. So, you know, if a judge, if a bailiff, if a judge doesn't sign some sort of certificate for a bailiff or a debt collector or any enforcement agent, an enforcement agent claims that they have, or a court official claims that this documentation is valid, well, it's not, because, as I explained to you in the last video, this signature is the only thing that creates liability or creates funds or responsibility. It is your signature that does that. You can do it verbally, I guess, if it's filmed or a reliable, truthful transcript is taken down. However, it is your signature that, you know, something that's signed not under duress, without coercion, wholeheartedly, and all the facts are given with full disclosure, and nobody gives these people authority. The judges don't sign anything, ever, and the High Sheriffs don't hold any role in it. You've seen that with your own eyes. That's the Deputy Under Sheriff of Greater Manchester, and he refers to all counties, High Sheriffs of counties. So that's referring to all counties. It's not just referring to the Greater Manchester region where that particular one is based. So that's our replies. That's where we are at the moment. And then to that, I did receive one more reply on the 7th of April, which is addressed to me. Well, not addressed to me. It says House of Davies. So they do recognise my house. And then they go on to say, Dear Miss Davis, spelt wrongly, I am writing on behalf of the Chief Executive to acknowledge and thank you for your letter dated Thursday the 31st of March 2016. I can confirm your comments have been noted. Your letter and the accompanying documentation have been forwarded on to a senior office responsible for council tax for information. Thank you for bringing this to Mr. Patterson's attention. Yours sincerely, Joanna Rose, Administration Assistant. So my comments have been noted. Well, they're not comments, they're facts. And it's not, let's hope that they take it as more than just information and they actually act, because they are required to act upon this. And if they do send the contract back to me, I will ask them, I will again tell them for the third time that I've declined it, and ask them to provide evidence by way of a formal contract that I am obliged to comply with acts and statutes. I don't remember ever signing that. So, and the reason I don't remember is because I didn't. So there we are, and I've actually revoked the right to vote. I'm not registered on the electoral roll anymore. So therefore, there we have it. So I don't vote for this company. I don't recognise them as an authority. They're not. And, you know, no more than Sainsbury's or anybody else. So that's where we are on part 2. I'll post the letter in the comments so you can have a read of that, and I'm sure you'll be able to find the other letters on the internet, and you know, circulating around various groups and stuff on social media sites. So hope that was helpful. When I hear from them again, I'll upload a short video for part 3. Alright guys, take care, bye.